Now, the next form of intellectual property is industrial designs. An industrial design protects the look and feel of a product. This is also referred to as design patent. The patent we discussed earlier, a patent protects inventions which are primarily functional. But if the product that you're making has a look and feel also, that is protected as a design. And what a design protects is designs of products or articles that are aesthetic and appealing to the eye. To get design protection, your design has to be novel, distinctive, different from what is already existing. It should be original, it should have originated from you, and it should not have been published earlier. Term of a design is for 15 years, and like patents, designs have to be registered. Only on registration you will get protection. And these are territorial. Once you get a design in one country, it is valid only in that country. If you get a design registration and somebody copies the same design for the same article or a similar design for a similar article, then that person will be liable for design infringement. So you see on your screen, you see Crocs. There is a design of a Crocs clog and design of a Bata clog. The test to determine whether there is design infringement or not is the test of substantial similarity. I'm sure you'll remember this test from copyrights. We discussed that to determine whether there is copyright infringement or not, courts will check if two works are substantially similar from the point of view of an ordinary viewer. The same test is adopted here also. Is the Bata design infringing on the Crocs design? Croc actually registered its design and filed a case against Bata. So the question you have to ask yourself is it substantially similar? So Bata was actually supposed to be liable for infringement in this case. However, Bata made a very interesting argument. In fact, their team found a very interesting information that actually helped them win the case. They found a picture from the website of Crocs, which was published before the design application was filed, which showed the same design. In other words, Crocs actually published a picture of this design, which they wanted to register as an industrial design on their website even before they filed for the design. And the court, by looking at that, said it is already been published. Once something is published, you cannot get design protection on it. And therefore said Bata will not be liable here. In fact, this is one important point you need to remember for both patents and industrial designs. The moment you publish, or the moment you sell a product in the market, you lose your opportunity to get patent or design protection. So if you are looking to protect, you have to protect it before you sell, before you commercialize, and before you publish. Patent law provides a very narrow exception for publications, but that is very narrow and difficult to prove sometimes. So it's always advisable to first file and then carry out your commercial activities.